Oh, hey friends, it's Josh, Santa Barbara dog walker. No dog today, and also not in Santa Barbara, outside of Breckenridge. Um, Talking about what to me are interesting subjects in the trust and estates administration process. I thought I'd do a little vignette on what the heck is probate. Seems kind of fundamental to do this, but there's a lot of misconfusion about probate. Probate is the process of transferring assets from a decedent, a dead person, to whomever is supposed to get the assets after they die. And the process is overseen by the courts. I'm in California, so it's California probate that I'm familiar with. And what happens in a probate? Probate happens when the decedent had no expression of what was to be done with their assets. That's called dying intestate. They just never got around to writing it down. And there are rules in California that say, hey, look, if you aren't willing to take the steps to define who gets your dough when you die, we, the state of California, are going to set our own rules on the intestate succession of the assets. Who gets your stuff when you die if you don't take the steps to write down who gets it? So one way of getting into probate is you just never write down anything. Second way of getting into probate is you have a trust. You went and paid an attorney to draft you the nice XYZ family trust. And we all know that setting up a trust avoids probate because the judge doesn't have authority over the trust. But you forgot to put some stuff in it. If you forgot to put the house in the trust, it doesn't do you any good having a trust. The things that are outside of the trust have to go through probate. And that happens with some frequency, that people go through the process of setting up an estate plan, and then they forget to transfer title of their stuff into the trust that they set up, and then they have to go through probate. But at least in that case, there is an expression of what the decedent wanted. They have a trust that says what they wanted. Usually they have what's called a pour-over will that says, if by accident I forgot any assets that should have been in the trust, I want those assets to go through the probate process and be lifted up and transferred into the trust so that my instructions that I did write down are fulfilled. But I recognize that I kind of messed up by not putting all my assets in the trust. Okay? So those are the two scenarios of how you get in probate. There's a third way, which is you don't do a trust, you do a will, but that's pretty much a blending of the two. You end up in probate. What is probate? Probate is a oversight process for the distribution of your assets. Step one is to give the judge the notice, hey, so-and-so died. Grandma died, and we looked around. We can't find a trust, or we do find a trust, but we also found out that she forgot to put the house in the trust. So we have to probate that asset. So the first thing that happens is somebody has to be identified as the executor, the person that is going to represent the deceased grandma in the process. In California, they're not called an executor. They're called a personal representative, but pish posh, it doesn't matter. They're the person that's responsible for settling grandma's estate and taking these assets through the retitling process. So, step one, you petition for probate. Judge, grandma died. Here's the death certificate. Here's the will that she wrote, or the trust that she wrote, or we can't find a trust. And I, the eldest daughter, nominate myself to be the executor of the estate. All right. So all of the heirs have to have notice that that's happening, because maybe one of the other heirs says, dude, I don't want the eldest daughter doing it. She's a knucklehead. I want to do it. I'm the nephew, but I happen to be a trust and estates attorney. I'm better positioned to be identified as the executor or the personal representative of the estate in this case. So step one is the judge has to decide who is going to represent the family, the assets in this probate process. Who's the judge talk to? Who has that authority? Usually it's written down. We're looking at a will or a trust document that expresses what they want. Sometimes it's not there, and we just have to make the argument to the judge, hey, Sally should do it because she knew mom best and she's the best one. The other heirs can say, no, I think I should do it. But eventually the judge says, okay, you're the person. You get papers, is what it's called. You have the authority to act on behalf of the dead person's estate. That's step one. Step two, you now have to marshal the assets. That means you have to take control of them, change title of them, bring them into the probate process by having them valued. So the judge is going to need to know, so how much is that house worth anyway? And the checking account that wasn't named in the trust. And you have to do what's called a date of death valuation. What was the sum total of all the stuff that either should have been in the trust and wasn't when Grandma died, or was never in a trust because Grandma never got around to it, or Grandma wrote a will expressing who she wanted to get her stuff, but she never put the stuff in trust. So step two is the marshaling of the assets, identifying the value of every asset in the estate, bringing it under your control, having the authority that the judge gave you. Then you have to do an account of the assets. You got to pay off all the debts of the decedent, any credit cards, mortgages on the house, personal loans, debts to the hospital, whatever it is. Pay off all the debts, but you can do that now because you have control of the assets. So debts have to be resolved. As part of the debt piece, a notice has to go in a public way, usually a local newspaper. It gives notice to everybody that, hey, Grandma died. If she owed you any money, now's the time to come and tell me that Grandma owed you money. Because if you don't act now, you're not going to get any money. So there's the public notice of death and the opportunity for creditors to be heard. Then there's the allocation of the assets. Okay, now that we've got control of the assets, now we know the value of the assets, now that we've paid off the debts, now that we've given notice to the world that Grandma died and that now's the time to pay off her debts, then we get into the disbursement of the assets. And this is where the personal representative, the executor, cuts checks and gets to write checks to the grandkids and the kids and the charities and whoever they are. So checks get cut. And whoever receives the check has to sign off on it, give a receipt that says, yeah, I got the check. And then the trustee has to provide an account to the judge. Hey, this is what I started with. Here are all the expenses that I paid. Here's the notices that went out. Here are the checks that I cut. Here are the receipts for the checks so that the judge knows. And then the probate is closed and it's over. That process usually takes a year to a year and a half, depending on the availability of the judge, the calendar that they have. An executor can do it on their own. There's a lot of legal forms to file. There are some helpful YouTube videos that I've seen of really smart probate attorneys helping fill out those forms. So that's one approach. If it's over your head, you can hire attorneys that specialize in settling probates. Anados Law does that, so consider us. The expense for attorneys to settle probates is kind of on the high side. It's kind of for $1 million estate with assets that need to go through probate, it's like $12,000 is what the state statute says how much the attorney's supposed to get paid. There's some other miscellaneous fees, but kind of use 1%, maybe 1.5% as the cost of settling a probate. So that's all I got from the unnamed pond outside of Breckenridge. Anados Law is the company name. Trustee-help is the URL. Ciao, folks. Call us if you think we can help.